Judge Mize will lead us in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We want to remain standing. We're going to have a moment of silence. As most of you all know, Major Cody Quirk lost his life a few weeks ago. He's an alumnus of this fine institution. We want to have a moment of silence for him and the other lives that have been lost recently in this conflict. Thank you. You may be seated. Okay. First, I want to thank a few people today. Annette Pitts, the director of the Justice Teaching Center, and Dr. Jeremy Martin, the president, for having us and hosting us again. I would also like to thank Justice Fred Lewis, who I think wants to say a few words before we get started.
May it please the court, I'm Fred Lewis. I'm a member of the Board of Trustees and member of the faculty here at Florida Southern. I'm here this morning to extend to you all a very warm welcome. It's important to the Board of Directors, our President, Dr. Jeremy Martin, our Provost, the Executive Vice President of Academic Affairs, Dr. Tedder, our faculty, our staff, and most importantly, our students. It's this type of thing that carries on the protections of our constitutional republic and our students understanding what it is that's done, what we need to have, and we thank you so much for going out of your way and taking time to be here. So we extend to you the warmest of welcomes, and please enjoy our campus and have a great day.
Thank you, and please extend that back on our behalf for being gracious hosts as you've been in the past. Just so for everyone else who may not know, when we first started and didn't have a place to meet, this was our home courthouse for the first little while until we were able to find we would go between Orange County's courthouse and then and here when they were in Polk County. Now we have a more secure facility over at the courthouse in Lake Alfred, but you all have been very gracious hosts all the time and have really helped this court get off its feet now for the first 3+ years that we've been doing this. So it's good to see you again, and thank you for your hospitality.
It's our pleasure.
Okay, want to just go over a few ground rules for everyone here. This is a session of court, and make sure your decorum always matches that. You know, if you need to talk or have a discussion, please take that outside. Please stay off of your phones, turn them to silence or turn them off during the proceedings so it doesn't interrupt anything. We have one case before us today. But first I want to introduce you. I already introduced Judge Mize here to my right, and then I have Judge Joshua Pratt here to my left. And the panel has one case before us today, and that is the case of Bradley and Sarah Geis versus Peter and Carrie Fleck. And Mr. Brownlee, over here, would you like to reserve the customary 5 minutes?
Yes, sir.
Okay.
May it please the court. My name is Mike Brownlee, and I'm here on behalf of the appellants, Brad and Sarah Geis. You would know it from the 9 million pages of briefing we made you all read, but this appeal turns on a really narrow question of law from our perspective, and it's whether the trial court applied the correct test in assessing whether the Flex dock violates the Geis's riparian rights, specifically the right to an unobstructed view of the lake and their ingress and egress from the lake. Our position is the trial court used the wrong test. The trial court employed an unreasonable interference test, which comes from a small handful of cases that deal with non-navigable waters and privately owned submerged land, not navigable waters like we have here, and sovereign submerged land. So these are different ball of wax. The proper test is comes from the Hayes case from the Supreme Court, Florida Supreme Court in 1957. And that case laid out 3 considerations a court must make when it's deciding whether there's a violation of riparian rights, and it presupposes, and as does its progeny that come after it, that there's some manner of identification of the boundary, whether it's a line drawing. In this case, it should have been a line drawn to figure out that common riparian line, but there has to be some identification of the area, the competing positions of the area of
So it
riparian
sounds like
rights.
in your brief, you did 2 things. One is the argument you're making now, which is the trial court used the wrong standard. And you had a preliminary argument before that, which was the trial court erred by not using the parties' agreed standard. In other words, it should not have come up with its own standard. It should have used what the parties agreed.
Correct.
Can I ask about that preliminary issue? Because I totally understand if you think the standard was wrong, and that's what appellate courts are for. I didn't quite get that argument of the trial court didn't have a right to try to figure out what the standard was if it disagreed with our standard. Because that would seem to me to say the parties could stipulate to the wrong law.
Right.
Is that the position, that if the parties come in and say this is the law and they both agree, that the trial judge just has to do it?
No, of course not. I mean, it's a trial court's job and prerogative to say what the law is, and if it disagrees with the party's position, it can do, it's permitted to do what it did here. It's not tied to what the party's saying. So that's not like a party presentation problem, or the trial court's allowed to do what it did. It just used the wrong test. But it's noteworthy. I mean, when you've got a bunch of smart lawyers who've been litigating a case for a really long time, and they see the law one way, and there's no dispute over it, and the trial court comes up with something else.
So counsel, I guess I'd like to turn then to Hayes v. Bowman, because I know the parties have seemed to assume that that is the case that would apply here. And I would like to maybe just explore that. So it seems like the parties, there's no dispute below that there was sovereign submerged land that was owned by the state of Florida. So that's something that's held in trust for the people, correct?
Correct.
And the parties seem to assume that Hayes v. Bowman applies, but Hayes v. Bowman had a particular unique set of facts. It seems to be that there was a channel, that there was an equitable distribution test that was created, and as you mentioned, there are these 3 factors the Florida Supreme Court discussed. But it seems to me that there was a statute there that was very specific that the Supreme Court relied upon at the time that required them to apply that equitable distribution test when there is a channel, when there is this sovereign submerged land that's being distributed. So can you speak to that?
Yeah, Your Honor. I mean, it's a different set of facts. It is, but the cases that have come since then, and I think most notably the Brown decision that the second DCA released recently, it's been expanded to different types of water and a variety of different circumstances.
So does that mean you're asking us to expand it as opposed to apply it?
Well, in the sense that I cannot point you to a case where you have 2 property owners on a lake with competing rights. I suppose it would be, I think expansion's the wrong word. Well, maybe it's a fair word. That's a
Well,
small.
when I look at Hayes, I mean, the big different factor was there's a statute pertaining to dredging and bulkheads, right? And this case involved dredging and bulkheads. And we don't have a statute. This case doesn't involve dredging and bulkheads, and we don't have that statute. And they did discuss some of the common law principles, and then the court kind of went on to say, and we've got this statute here that governs this scenario. So it would seem to me that if they're applying a statute that governs a particular set of circumstances, and we're in a different set of circumstances, which we don't have a statute, that would be a pretty big differentiator.
Yeah, I suppose, but I think, Hayes has been applied in, dozens of cases we cited in the briefing where.
Why do you think they didn't mention it in Duval?
I don't know.
Because like 2 years later.
Well, excuse me, why didn't they mention Hayes?
Yeah, why didn't the Duval
Because
court mention
Duval, if I remember correctly, I think that was it's privately owned submerged land. It's not sovereign submerged land, and it's not navigable water.
it? I'm thinking about this in terms of like why Duval wouldn't be more apt here. The third, in both cases, right, whether it's whether the lake is owned by the state of Florida or a private party, as to the 2 landowners fighting over their riparian rights, it's kind of the same situation to them. They have riparian rights to a lake owned by a third party, right? And in one case, the third party is the state of Florida, and in another case, it's another private party. As to their dispute and as to their rights they're fighting over, does it really matter who the third party is that owns the lake?
I would say the case law has drawn that line in the sand, and I don't think there's been any meaningful dispute from the other side that, or anywhere, that would be that distinction makes a difference in the case law.
Well, counsel, I guess then speaking to the case law, are you aware of any case that holds that the common law of England, something that would presumptively apply, would require a meets and bounds distribution equitably of what is quintessentially public property for the benefit of two private landowners?
No, Your Honor, but the cases are very fact specific. I mean, that's part of the nature of, I think, figuring out the riparian rights. What I can tell you is that if you're trying to determine whether there's interference, whether there's an encroachment, you have to have a defined area. I mean, and that's also in the nature of a declaratory judgment request is, the parties are uncertain about their rights. Who has what? Let's make a call. I mean,
But then why didn't the Florida Supreme Court apply that principle in the Duval case just 2 years later when it was non-navigable, privately owned property? It would seem that would be the sort of case where that principle would be at its zenith because it's actually privately owned. So they said instead that you have to look at the co-relative rights and look at whether there's a reasonable interference, is my recollection. And so if that's the principle there, when you have public property, why would we then apply something different?
I don't have a good answer for you for whether the private versus public distinction. I know the cases make that distinction, and it seems important for riparian rights law. I think the second.
What way, can you expound on what seems important for us not to make, to have to follow a distinction like that?
Sorry, Judge Archuleta.
So can you elaborate on why you think it's important for us to stay with that distinction?
Because that's the way courts have determined how to.
But from a landowner, property owner standpoint, what would the challenges be if we were to decide that that's not how we want to follow?
Well, I think it'd be really difficult to ascertain if you don't have some sort of identification of the riparian area that's at issue and where your rights begin and end. And again, the Hayes is clear that there doesn't have to be there's no mathematical perfect formula for it. It's going to differ.
Why would private or public matter in that regard?
I don't know that it would. But the Brown case from the second DCA that came out recently and that cites 419 Southern 3rd 711 is, it's very, very close to our case. If it, except for it involves a river, it's about dead on. And the court in that case excluded a dock, identified the riparian areas like Hayes instructs, and then drew the line around a dock just because it was there before, which is kind of what happened in this case. That seemed to be what drove the trial court's decision. And the second sent it back and said, no, you've got to go analyze it under the Hayes factors and explain why those boundaries are different.
If we rule against you, is there any way we get around certifying conflict with Brown?
I don't think so. I don't, unless there's a meaningful distinction between a river and a lake, and I don't think there is.
One flows and one's a more stagnant body of water.
Fair enough. Maybe in terms of the rights we're talking about here, which is a view and an ingress and egress, I don't think it makes a difference. I suppose it could. Yes, I would urge the court to look to Brown. I think that's the right decision, and it's in line with Hayes. And again, I know Judge Mize, like you said, or intimated that just because the parties agree on the law doesn't mean the court has to accept it. That's not a separate error we've raised, but it's noteworthy.
It kind of seemed to be a theme of the brief.
Yeah, well, it's an out of nowhere, ruling, so to speak. It's sua sponte, and it's to underscore that this is.
You don't think it was a close call?
No, not as far as the view. I do not. I think I'll reserve the rest of my time for rebuttal unless the court has any more questions.
Okay.
Thank you.
May it please the court. My name is Kimberly Ashby. I represent the Appellees, Mr. and Mrs. Fleck, and they are here today in the courtroom. The court should affirm the amended final judgment that was entered by Judge Netcher because he identified the Hayes test. He applied the Hayes test. As a matter of law, there is nothing for this court to reverse. Everything else the trial court did was to make findings of fact. And this court should not be asked to reweigh any of the facts. We certainly are not asking you to do that.
So counsel, assuming that the Hayes test does apply, how is it that the trial court actually satisfied that? Where can you point to in its judgment that it specifically analyzed each of those factors and applied them to the facts of this case, other than just citing Hayes?
Certainly. So the amended final judgment that followed the original final judgment makes specific findings of fact on the Hayes factors and the riparian rights by category. The ones that were present here, specifically access, sometimes called wharfing out, the ability to get your boat to and from your upland property, and the right to a view. And he specifically highlighted, outlined, identified the testimony that the court received on both of those issues. As for access, he specifically identified the fact that the Geises have a boat, have a jet ski, they back that boat out unobstructedly to Lake Down and use their boat without any
But counsel,
impediment.
how did the trial court equitably distribute anything? It left the rights, kind of in the ether without drawing, I think that's kind of what the parties at the trial seem to say. Judge, you need to draw these lines so we know exactly where these rights lay. And did the trial court draw any lines?
Not into the water because they're not property rights into the water. So the upland property boundaries, I don't think were in dispute. What the court said was, it's one thing to affirm a trial court's drawing of a line as an appropriate equitable result, and quite another to conclude that line drawing was required. If the Florida Supreme Court, if the Florida legislature thought that line drawing into the water is what needs to happen, one of the two of them would have said that by now. The Hayes decision was 1957, a very good year. It's 69 years old this year. And there are only a handful of cases that address riparian rights disputes. Since then, it's sort of an if it ain't broke, don't fix it kind of thing. And yes, the Hayes decision said there's no formulaic construct that we can give you, given all of the different ways that two abutting upland owners can own property and have riparian rights. One need look no further than the motion for rehearing that was filed by the Geises in this case, where they
Well, counsel, I guess turning back to the Hayes decision, can you point to anything in Hayes other than the citation to that statute that it relied upon that would require an equitable distribution of publicly owned land vis-a-vis to private individuals?
The court said each case necessarily must turn on the factual circumstances, and it's absolutely impossible to formulate a mathematical or geometrical rule that can be applied to all situations, and did make reference to an equitable distribution that the court necessarily must determine from the lay of the upland shoreline, the direction of the channel, and the co-relative rights of the adjoining upland owners.
But when it said all cases, and obviously if Hayes applies, we would be bound to apply it to the set of facts, and we would have no problem doing so. But when it says all cases, isn't that necessarily limited to the facts of what it's talking about channels and the uplands in relation to that, and essentially the dredging of the bay there?
If you review Florida Supreme Court opinions, really all DCA opinions, they go out of their way when they say that this is specific to these facts, and this really has to be tied down to these facts, because otherwise it's going to have a reverberating effect that we don't intend. And the Rizzitano opinion of this court is dog-eared in my office, so we are familiar with dicta being more controlling than it should be and having those reverberating effects. The Florida Supreme Court has had multiple opportunities to take jurisdiction, revisit Hayes, refine what's been done. And over the DCAs have used Hayes. The Brown case, which I'd like to address next, the Brown case says Hayes is the controlling case, and nobody's disputing that.
But counsel, isn't the Florida Supreme Court a court of limited jurisdiction? They don't have certiorari jurisdiction like the U.S. Supreme Court, so they can't just pluck a case from the stream, and if there's no conflict, there presumably be no reason to. But are you aware of any case where the Florida Supreme Court, subsequent to this, has applied this reasoning of Hayes to a similar set of facts?
No, I am not. We certainly would have cited that to the court, but neither have they taken the opportunity to adjust any of the holdings of Hayes. May I address the Brown case? Because I think, having it come out of the second, that's my alma mater. I was a clerk for Judge Campbell right
I
down
was
the
wondering
street.
what the odds of a case, that similar coming out at such, it's not like you get a ton of these riparian rights cases. It was a pretty big coincidence that it come out 3 weeks later.
Yeah, let me tell you why it's not similar, please. First of all, it's an accretion case, and this is a really important distinction because the party in opposition that ultimately prevailed was a landlocked parcel owner, and a replatting showed accretion suddenly gave them access to the water. Suddenly, they're a riparian rights owner when they weren't before. And all the while, this dock and pier that pretty much clouds the property to this pinky toe that they got from the accretion. And the trial judge said in the record, I've read the briefs, we've all read the final judgment and what was in the docket. The trial judge said, I hear you, I understand Hayes, but I'm not going to apply it. And as a matter of law, the second DCA had no choice but to say, you were supposed to apply Hayes. And so it's completely consistent with what Judge Netcher did here, which is to apply Hayes.
The council did, with due respect to our sister court, did the second DCA kind of do a first analysis of Hayes to determine whether it actually applies outside of that set of facts and outside of that statutory context?
Did they need to, or did they choose to? I think those merge because Hayes is controlling to the extent of what do adjoining upland property with riparian rights owners, what standards do we apply? And I agree that if there is another case that is more applicable, that should be cited to. Nobody's citing anything, so everybody's still citing to Hayes. Why? Because Hayes really is one size fits all, because there's so much elasticity in what needs to be considered. Does DEP, Department of Environmental Protection, what is its charge? To protect the environment. And so when they're drawing lines, I mean, I brought a copy of their guidelines for drawing lines. It's so that we are consistently drawing lines for the erection, installation of docks and piers, period. We're not making a determination about riparian rights. We don't have that kind of authority.
Counsel, why do you think the Duval court didn't cite Hayes just 2 years later? If Hayes is one size fits all for these types of disputes.
I don't know why, but they don't recede from Hayes. They don't.
No, they don't even mention it.
They
cite
don't.
it. Yeah, so that's my point. They had to have thought it didn't apply to the case, right?
Well,
I mean, it was just 2 years earlier. It's the same court. If they
Yeah, I
thought If they
understand.
thought it applied generally to all cases involving riparian rights of adjacent landowners, it seems like they would have mentioned it because Duval involved riparian rights of adjacent landowners, right?
right. But really, when you look at what Duval's holding is, it doesn't vary what the trial judge did here in making the determination of what.
No, I'm not saying Duval, mandates reversal in this case. I'm just saying the idea that Hayes is controlling as to all cases involving, adjacent landowners fighting over riparian rights. You had another case with the Florida Supreme Court 2 years later, and they didn't mention it.
This is, I'm a book person. When Shepherds went away in paper, it was a tough day for me. I mean, how do some cases make it through and become that seminal case and others don't? And maybe I hate to say maybe it's just that simple, but because Hayes has been uniformly applied by courts throughout Florida, and one of the things, the unintended consequences of a riparian case, any case that deals with real estate and corporal rights attended to those, is a huge boulder in the pond if you're going to change the rules for all the properties that we have in the state of Florida that butt water. I mean, you know, the
So
stats.
counsel, so I guess just practically, how does that rule, assuming that Hayes applies, how does that rule actually play out on the ground? If a judgment is entered, declaratory judgment, and there's an injunction, I guess presumably someone has to remove their dock. But let's say someone is seeking to enjoin someone from swimming on the publicly owned property out from their property. Can they get a riparian line drawing as to that?
No, thank you. Absolutely not. And what I was trying to insert earlier is that it jumped off the page to me when this wasn't appellate counsel. Trial counsel said, we have to have a line, otherwise how do we know who won? And I said, this is not an Olympic heat,
Well,
okay?
I guess
So
that's my
views-
question. So riparian rights, there's a number in the buckets. There are certain special rights that enter only to the landowners, such as a right to view, the right to ingress, egress from your property. But then there are rights held in common with the public, things like fishing, swimming, boating. But another special right that attaches to properties is the right to wharf out to navigability.
Right.
And so you have these kind of rights you have to compare against one another because they're a little bit in tension if someone has a dispute. If there's no dispute, it's fine. But which of those rights under that rule are required to have the line drawing where people have to fit within, you know, the four corners of this line that's drawn on public land?
If I'm building a dock, if I need a permit. So that's when, you know, because I'm not going to build a dock on property that isn't aligned with my property per the admin code, okay? But that is not riparian rights because, to your point, it's a public trust waterway. And I may have some special rights to wharf in and wharf out, or access and ingress, and to a view, but you and I can both have views. And to say, there's got to be a winner and a loser, and I've got a view of the lake, as do you, there's no winner or loser, we're both winners. So drawing lines it doesn't make any logical sense. What am I saying? You can't look obliquely across where my view intersects because there's a line there. How would that even work? It wouldn't, and that's why that's not the test.
So let's just assume then for the moment that the Hayes test doesn't apply. Why shouldn't we apply the reasoning of Duval and other Florida courts in the non-navigable, privately owned context that kind of obviate that problem? They just apply whether there's an unreasonable interference. The trial court weighs all the things, all the evidence the parties present. It takes into account the character of the waters and the lay of the land. You know, all these things. Why can't we just entrust trial courts to do that when they make these sorts of determinations all the time in other contexts?
Now I think we're talking dicta, because what was done here is not a private land, and what the trial judge did was exactly what you're suggesting trial courts could be doing, is making.
And that's my question. Why shouldn't that be the test, assuming that Hayes doesn't apply if we're on a more blank slate as a 6 DCA where we don't have binding precedent, or at least we don't have a horizontal stare decisis that we might give some respect to, and I'm aware of no vertical stare decisis other than Hayes. And if we decide it doesn't apply, why shouldn't we adopt the reasoning of Duval, the Florida Supreme Court 2 years later, and the other Florida courts who've applied that?
To the extent that you would agree that what the amended final judgment says is in accord with Duval, 100% agree. 100% agree. One of the issues that we have in this case, and that's why it's important to see Brown is Brown is the easiest case to distinguish, the easiest case, because the judge said, I'm not going to apply this test, and made up his own. And so if there is a test that is a legal standard, and that test is being applied, this court.
If we don't think Hayes applies, the Brown said the trial court should apply Hayes. If we don't think Hayes applies, and we don't think the trial court applied Hayes, we disagree with you that the trial court in our case applied Hayes, wouldn't that put us in conflict with Brown? Second DCA said you had to apply Hayes. Our trial court we find that it didn't apply Hayes, if we disagree with you on that, are we in conflict?
I don't think so, and let me tell you why. Because if the facts of Brown, yes, he said, I recognize Hayes, I'm not going to apply it. What I'm going to apply is a first come, first served. And there was no legal basis for that.
Yeah, and the second DCA found the trial court's reasoning was wrong, but the reasoning it said, it put in place was you should have followed Hayes.
Right.
And so if we find the trial court did not follow Hayes, it did not have to, right? We don't think Hayes is binding. I'm not interested in the trial court in the Brown case. The second DCA of the Brown case, their holding was you got to apply Hayes. And if we say you don't have to apply Hayes, are we not in conflict?
So the conflict that you're identifying is that they're saying Hayes is a mandatory application, and we're saying, no, it's not, though this amended final judgment should be affirmed because it was a proper test that was applied.
Yeah, well, we would find if we determined that the trial court did not apply Hayes, but nonetheless got it right, would we be in conflict with Brown?
A direct conflict where if you were saying you shouldn't apply Hayes,
Because you
and the
said
second,
Hayes is like a catch-all case that applies to all, and that was your, I don't know if I'm putting it exactly, but you basically said.
One size fits all.
Yeah, one size fits all, that it's the overall governing case for adjacent landowners fighting over riparian rights. If that's true, then, second D said you got to apply it. We disagree with that and say it's not the catch-all case. All right, so second DCA seems to have agreed. Hayes is the standard. Hayes is the catch-all. If we say it's not the catch-all, that seems to be a direct conflict to me.
so the second DCA reversed the trial court because he found he didn't apply any sort of test. He didn't apply, I tell you, just sort of whole cloth.
But the second DCA said you got to apply Hayes, didn't it?
They
I mean,
did.
It didn't just say the trial court got it wrong. It said, here's how the trial court gets it right. Apply Hayes.
That's right.
And so if we disagree with you that the trial court here applied Hayes, but nonetheless affirm because we say the trial court didn't have to apply Hayes. We don't think it's the catch-all case. Is that not a direct conflict with Brown?
If this court affirms, as I think you should, Judge Netcher's very well-reasoned amended final judgment and all the factual findings, and find that test does have support in common law of Florida, and we do not require a Hayes finding as such, but the elements are so aligned, it may not be a direct conflict. I mean, direct conflict at the Florida Supreme Court, Justice Lewis could tell us all about it, that's a tough standard. I mean, it's got to be a direct conflict, and I don't know that that's what it
you can have direct conflicts on
is.
specific issues or broad issues, right? As long as the conflict is direct, there actually are adverse decisions that are necessary to the holding. And it would seem like one thing that would be necessary to the second DCA holding was Hayes is the governing standard for these types of disputes, as a catch-all, as you put it. And it seemed if we were to find that Hayes is not the governing standard, those are broad holdings, but they're still holdings, right? Sometimes holdings are specific, sometimes they're more broad. One second DCA said Hayes is the governing standard. We say it's not. Even though there's lots of different things about the cases, but they would both involve some broad holding as to Hayes as a preliminary determination, wouldn't they?
There's no doubt that there is an interlacing of the issues, okay? But is it a direct conflict? I don't think it's going to hit a direct conflict standard. And since the court brought it up first, I would like to also point out, in Brown, Mrs. Thomas laid down her weapons. She just stipulated to a final judgment and agreed to the boathouse being removed. I think she ran out of money. She lost her appellate lawyer before oral argument.
And counsel, I asked this question of your friend on the other side, and my apologies if I earlier asked it to you in some other form or fashion, but are you aware of any common law requirement that would require us to do a meets and bounds equitable distribution of publicly owned land as to privately owned persons?
Absolutely not. I think that would be completely ultra vires by the court. How do we meets and bounds what is owned in trust for the people?
And so I guess my last follow-up question, doesn't that then suggest that Hayes is limited to its facts because it was applying a statute that the Florida legislature enacted that directed equitable distribution of publicly owned property vis-a-vis to private landowners?
There's nothing that says that equitable distribution doesn't apply under other common law precepts of competing upland owner rights and views and working out
There's also nothing that
access.
says it does, is there? I mean, it's all Hayes. If we don't think Hayes applies, there's nothing that says don't use equitable distribution, but there's also nothing that says use equitable distribution, other than Hayes and, cases applying Hayes, saying that it's mandatory under Hayes.
I think this goes to, I'm running over time, so thank you.
You can finish answering the question.
Thank you. I think this goes to the whole world of trespass. Really, I mean, it goes, if you want to go that direction, for sure, what are the common law precepts that we exercise in any sort of competing trespass, whether it's ground, water, air, any of it, even noise?
The trespass cases, the ordinary set of facts is someone owns the land. They have that sort of ownership, and that's why you can exclude someone. This is to ask to exclude from public property.
Right, which you cannot do. May I just make one closing? So Judge Netcher loves the law, and when he wrote this amended final judgment, as appellee, it's my job to extol the virtues of the order I'm asking you to affirm, and so I'm certainly going to do that. This court, and thank you for the moment of silence, cannot do much about peace in our world, but a PCA in this case would bring peace to Lake Down. That's what we're asking for. Thank you.
Thank you. Mr. Brownlee?
Your Honors, I think a PCA in this case would just lead to another dispute, which is why identifying the riparian area is critical. Judge Pratt, you asked, why do we need to do that, or why is the application of Hayes important? It's because otherwise if you don't have some identification of the boundaries, you're coming to court every time for an ad hoc determination where beauty's in the eye of the beholder. I mean, that sets up a really tough framework for people who live on the lakes, and there's a lot of them in Florida, and that's valuable
Is
property.
that based on an argument that this works out better as a policy? Like, this will lead to less disputes? So take that into account in making a common law ruling?
Yeah, I mean, it's not a, yeah.
Are you aware of any other case where the Florida Supreme Court or another court applied a specific statute governing specific circumstances, and then it became the seminal case on factual disputes and disputes not involving that statute?
No.
If we were to say Hayes was the catch-all, that's the seminal case for how to apply riparian rights between adjacent landowners, would that be, to your mind, the only time that at least you're aware of where a court has taken a case applying a statute and said it's a similar case in cases not applying the statute?
Maybe, yeah, I mean, I understand the concern, I get it. I'll put it this way, I think you'd have to certify conflict with Brown if you don't go that way. And if you don't certify conflict, I think it meets the standard for a question of great public importance also. I mean, it's a big deal, people trying to figure out what are your rights and how do we go into court to solve them. And I know that this court's not in the habit of making policy, but it's common law and those are the ramifications.
Yeah, I mean, the trial court's order, I don't think the word reasonable appeared in Hayes. So I take your point that the trial court's order does not seem to apply Hayes.
It does not. That's the big problem from our perspective. And maybe it's not if y'all don't think Hayes applies, but everyone else does, and it would be a sea change. Does the court have any more questions? I don't think I have anything to add.
Have anything further?
Okay. Thank you, Your Honors.
Thank you, counsel. Okay, with that, court is adjourned for these purposes. I welcome counsel to stay around during these Law Day festivities. It's customary for us to open up for questions from those in the audience. I want to just caution you that your question should not go to the facts of this case or anything about this case or the law in this case. You're welcome to ask their attorneys about their preparation for cases like this or anything along those lines, but don't direct those sort of things. Or our preparation for cases like this as well, but not the facts itself. And, I'm going to ask Justice Lewis, do you mind kind of moderating and calling on whichever students and
I
faculty?
hope you understand the parameters of what the Chief Judge has just said, but there must be some thoughts or questions that you may have, but now you have an opportunity to interact with actually the making of the law with regard to a case like this. So what questions do you have? You didn't know all of them? Yes, sir.
Well, I believe that you actually override what I was going to ask. I worked plenty with litigation and trial press on the attorney side, but how do judges actually prepare for this?
Sure. So every judge, it's different, but my view is every case is important to the parties and the litigants in that case, no matter how big or how small. So I want to do whatever is necessary so I feel adequately prepared. So that includes reading all of their briefs, reviewing any parts of the record that are relevant that I need to look at, particularly the trial court's orders that are on review or any judgment that's on review. Internally, we have great staff, great law clerks who prepare bench memos, and so I'll review that or maybe task them with some additional research or do my own research. And then from time to time, if you have time, you can talk to your colleagues before, definitely after if it's OA. For cases that aren't oral argument, they're present to us on the papers. We might informally conference them or just circulate something to read. But every judge handles it a little differently.
Anything to add?
Just my personal learning process, I tend to take something I tend to learn something better the more times I read it. So I will typically read the briefs 3 or 4 times because just different things jump out at me each time I read it, and I mark them up really heavily. And so I just, whatever cases are relevant or, whatever, the trial court's order, whatever the relevant documents are, I tend to just read them over and over and over again until I feel like I've deconstructed them in my mind.
And I'll just add that kind of the process that we have to follow as a court, we have a constant stream of cases coming in, obviously, and those get divided up amongst the judges. So this panel of judges, we were each assigned 6 cases, and on 2 of them, each of us were the primary judge. So if something happens and we're going to write, or you heard the term PCA a few minutes ago, and I'll explain that in a second, whatever's going to happen, once we collectively make the decision, then that's kind of our case to go forward with and take the lead. In addition to these 6 cases that we get this month, we'll get 15 what we call OAWs, where oral arguments withheld, so we're not having this kind of a panel discussion in front of the parties. And then in addition to that, we'll get, I don't know, another 10 or 15 cases that just come from central staff on different types of things. You heard Ms. Ashby say that years ago she was a clerk for one of the judges. As Judge Pratt just said, we have our clerks that help us on all of these cases. We all use them a little bit differently in how we want to prepare and the things that come in. But it's a process, and we all develop our own process on how that works to try to make sure we move our cases. This is an excellent question. Thank you. There's one back over there. You mind standing up and talking loud? So. Okay. You want to start this time?
As I practiced, I saw how important it was to have a good judge. I had judges who I thought did amazing jobs and it really made the difference for my clients. I had judges who I wish would have done better, particularly in terms of preparation. Like, it really mattered to me when the judge showed up extremely prepared, and I could tell that they were ready to have a nuanced discussion rather than not being prepared to do so. And when I walked out of a hearing, I was a trial lawyer, and the judge was really prepared, win or lost, I felt like my client got the proceeding they were entitled to. If I felt like a judge wasn't as prepared, it's really heartbreaking because your client's life is on the line. Whether it's if you're a criminal lawyer, it could literally be their life. But if you're a business lawyer, or this is whatever the case, I mean, it is very, very, very important to those parties. And so So win or lose, if they feel like they got the right process, at least they'll feel like they got a sense of justice and the rule of law, if the judge adequately prepared and gave that to them. So I just wanted to give that to people.
Mr. Pratt?
Yeah, so I had the privilege to clerk for a few judges early in my career, then Justice Kennedy at the Florida Supreme Court, and then a couple of federal trial court judges out in Texas. That's where I really got to see the law from the inside, how they would interpret it and apply it, either to new cases or old. All of them showed fidelity to the law. But it probably wasn't until I was in the governor's office and actually doing lots of judicial interviews to help the governor in his selection process. That's where I kind of started to think about would I ever be interested. And it was just seeing such great candidates come through, it just encouraged me to be better in my career. And so after that, I went on to do a number of things that kind of helped prepare me. But you'll kind of find, for those of you who decide to practice, you kind of don't necessarily know where your career is going to take you, and that's okay. Just follow the things that interest you. You can kind of reinvent yourself several times during your career as an attorney. It's not like a one-size-fits-all proposition. And then even with the bench, there's so many ways to get there. Just have integrity, be honorable, follow the law, and do what it says.
And my path was a little bit different than a lot of people's, and it's partly I'm a little bit older. Justice Lewis and I kind of fell into an older model where you practice for a long time before you, it used to be that it was very unusual to see people take the bench in their 40s, maybe some at the trial level. And that's changed a lot over the last 20 years or so, but I've been a judge now. This year is my 20th year, and I served in the legislature. I've been general counsel for a couple of corporations and have my own law firm. And the opportunity, I had been a member of the Judicial Nominating Commission and, like I said, was in the legislature, and the opportunity opened up for me at 42 years old to be able to become a trial judge. So I was a circuit judge for about 14 years before becoming an appellate judge. I was on the second DCA that you heard a lot about today before they merged with some members from the 5th DCA and created us as a 6th DCA, which I addressed at the beginning. And Judge Mize was added right when we started, and so he's been on for right at 3 years, a little over 3 years.
Yeah, January 23.
And Judge Pratt's been with us for about 5 months, 4 or 5 months.
4 months, yeah.
So, yeah, everybody comes with different backgrounds, different experiences, and it's what, I think, going back many years, people looked at, once a trial judge does something, maybe there should be more than one person reviewing their work, grading their homework. So that's why we get a panel of us to review all of this information and make a decision.
Sure. So I think this kind of applies to all areas of life, that know what are your non-negotiables, what are your boundaries, the things that are important to you. And in your practice, you can obviously work for firms that you believe in what they do. You can work in government, upholding justice, whether you're in the prosecutor's office or public defender's office, like you're upholding law. And just always be above reproach. You want to, your good name is something that it's hard to get back and it's easy to lose. And so you just want to make sure that, again, those things are non-negotiables, that you won't go past a certain line. And maybe the attorneys can speak to, just you have to, on behalf of clients, sometimes coach them on the arguments you can and can't make. You as an officer of the court, you have a responsibility to the court and to the law that's independent of your client. But obviously, you're zealously advocating and doing your best to win cases. So,
I just think anything you do, whether whether it's something that will be seen and scrutinized by a lot of people, or whether it's something no one will ever know about but you should frame it as, if everybody knew about this and I had to explain it, would I be totally confident and comfortable explaining why I did it the way I did it and why I felt that it was right and ethical?
I'm going to ask the attorneys, do you all have any comments on that as far as things you can add to them about ethical representation and how you pursue the law?
So what did?
If you don't mind, stand up in turn so they can hear you.
So when people ask what I do, I tend to not tell them I'm a lawyer or an attorney. I tell them I'm a professional problem solver. And if I'm not part of the solution, I'm part of the problem. And that goes to your question about ethics and doing the right thing. Don't be part of the problem. And we're not talking about the case, but one of the things that, is endemic in what we have here in the state of Florida, that was given to us, by the English when we came back over, is there's a trust of the public land. And that public trust has other meanings when we go, this public trust legal system. And, the legal system right now, and probably should, is under attack. Is it working? Does it need, amendment? What can we do to evolutionize and make it better every single day? And my work opposition, I know, is exactly the same way. And it is a calling. It's not a job. You're called to do it, do it. If you won't regret it.
Mr. Brownlee, anything to add?
I would, like Judge Pratt said, I think you've got to decide who you're going to be and what your limits are and stick to it. If I say the record says X and it really says Y, if I say the case says X and it really says Y, and for the 10 years before of my career, I've never done that, but I do it one time. That's that judge's impression of you, and that's a big thing, So you really have to be careful about how you do it. And it's hard sometimes because explaining to your client, the client will read and say, why are we talking about all these facts that are bad for us? Because you've got to tell them the full story and deal with it. You have to sweep it under the rug. So.
Did I make?
Yes, sure, go ahead.
So, because AI is so topical, and you guys are going to live in AI a lot more than us guys, right? And what is AI? Is it what I type in and get a computer tape? And Judge Chu in the Ninth Circuit has this epic quote, and I want to give it to you. He says, AI doesn't take an oath. Isn't that awesome? And that's what we do. We have to take an oath before we get a membership to the bar, and a robot does it. And so thank you for letting me share that.
I think that's relevant not just to ethical issues, but whether you're thinking about going into the law or or any other field, over-relying on AI can stop you from mastering your craft. Like when I think about how I do legal research, even if I could, the AIs are wildly inaccurate, so I wouldn't, just that's enough reason to me not to just rely on them. But even if they were perfectly accurate, right? The process of digging through all the material myself is how my mind deconstructs the issue. And if it was all just laid out for me, even if I could read it, I wouldn't have the deeper understanding that I need. So A, don't rely on it because it's not, because it doesn't take an oath. But B, even if it was perfect, you're missing the chance to develop your own mastery by relying on it. And that mastery is what's going to give you an edge, I think.
I'll just add to all of that, and that was all excellent input. To the original question on ethics, and Judge Mize just touched on it, it goes beyond the law. Whatever you all decide that you want to do, what you want to be when you go out there, whether you're in the medical profession, the legal profession, you're architects, engineers, ethics is a paramount concern. And as Mr. Brownlee said, it's how people will see you, and you don't get a second chance to make that impression. We always hear that about a first impression, but it's every impression. It's an ongoing impression, and you just need to set your professional skills high, your skill level, your work effort, everything about you, so that you do it with excellence and know whenever you have to draw those lines.
And one other little thing I'll add, this kind of applies to all areas of life, but also give yourself grace, give others grace around you. I grew up in a time where not everything was on video, and now, anything and everything is, or it's all online. And I think that if you can show grace to your friends, your classmates, your family, and hope to receive it for any mistakes, big or small, that can go a long way.
Let me ask one broad question. these students are perceiving the field of law from a different position that we who have been in it for years. They're trying to make the decision, should I go to the law school? And number two, if so, where? And what considerations should I make? You gentlemen, you experts have all gone through different law schools. And I don't mean this as a try to get you to recruit for your law school, but the kinds of things that these young people should be looking at. If these were your children, what would you tell them today with regard to thinking about law school, and if so, where?
Well, I'll start on this one because I have 5 children. None of them, at least thus far, have elected to go into the field of law. And that's fine. My wife and I are perfectly happy with that. But what I just said about ethics, I mean, that applies to them in whatever position. As far as which law school, I think you can answer that question down the road. And in fact, it's going to be driven largely by how hard you work, what grades you receive, how you do on the test. I mean, there's, not everybody can make it into the top tier law schools, but there's some excellent law schools here in Florida. Judge Pratt and I went to FSU Law, and Judge Mize went to Florida Law, and we all get along just fine. It doesn't make any difference at all from that standpoint. We have other people on our court who've gone out of state and all over the place. So just work hard. When you get close to that, talk to people like Justice Lewis and others who can kind of guide and direct you as the types of things extracurricularly that you can get involved in that will help your resume stand out among others. Get involved in your community. That's what the bar is looking for, people who aren't just academic, but want to apply what they're learning and what their passion is to help the community. So, whether it's getting involved in food drives or whatever your passion is. The great thing about the law also that I will cover is that it doesn't matter what you like. I talked about engineering, I talked about medicine. You can do that in the law. There's people who specialize in those areas. You heard about riparian rights today. People specialize, not a lot of it out there, but there is a little of that. So whatever you find fascinating and you enjoy, you can do that with your law practice. Anything to add?
Yeah, just study hard in school, do your best. Treat the LSAT, if you take it, like it's a job, because if you do well, it can save you monies. You can get scholarships. Think about where you might want to practice regionally. If you want to go to a top law school, think about, are you coming back? Where do you want to take the bar after? And just be aware, obviously you want to go to an adequate, good law school, but the farther you get in your career, the less people ask you where you went. It's about, have you done a good job for your clients in your jobs, and it's where were you last and were you well respected there. So getting that first job out of law school is kind of like the biggest hump to get over, and then you just build off of that.
Good one.
It's a profession. I think Ms. Ashby said that. It is also a career. So do think about the nuts and bolts. How much debt am I going to incur if I'm going to incur debt, right? And if you're looking at one law school where you're going to come out $300,000 in debt and one that you're not, I would think about the one that you're not. I would think about where you want to practice. If you want to practice in Florida, right, that's a reason to go to law school in Florida. It's not the only reason, right? But typically a lot of law schools, your employment prospects are best in the region where the law school is located, right? There's some law schools that have a more national reach, but some have an advantage in their local area, and I think the schools in Florida fall into that category. Think about what type of law you want to practice and how that would fit into your life, right? So if you want to be a government attorney or a nonprofit attorney, that's one thing. You'll just need to go get a job. If you want to be in private practice, you got to think about who's going to hire me, because you can be the best lawyer in the world, but if you don't have clients, you're not a lawyer, right? Or at least you're not in business as a lawyer. So think, if I'm going to be a criminal lawyer or a business lawyer, which one of those types of clients am I going to be best able to get, right? If you're a criminal lawyer, obviously you're kind of marketing to the general public who has criminal issues. If you're a business lawyer, you may be looking at business owners, which is a smaller segment of the population. If you want to do healthcare law, you're going to be looking at hospitals and other healthcare entities. And am I going to be, not just enjoy that area of law, but am I going to enjoy working with those types of clients and able to gain them? If you're an appellate attorney, can be quite different than if you're a trial attorney, because if you're a trial attorney, your clients are generally, the general public or whatever sector, hospitals, businesses, whatever. If you're an appellate attorney, in a lot of cases, your clients, or at least the places you get your clients, are trial lawyers, right? Because the trial lawyers typically don't often do appeals, or maybe they don't do all their appeals. And when they win or lose a case and it goes up on appeal, they need to refer it to an appellate attorney. So the process of building a practice as an appellate attorney involves a different, type of marketing and reputation building than, say, a trial attorney. So think about those nuts and bolts. How much debt am I going to have? Where am I going to live? How am I going to get the types of clients that I want to work for? Or those types of things.
Yeah, I'll just follow up on that as far as the quality of life that you want. You have to think about what you want to be doing, because if you're a trial lawyer, you better make sure that if you're a spouse and you have kids, that they have a job that they can look after it, because there's times where you're going to be staying till midnight or 1 and being back in the courtroom at 8 o'clock the next morning. And so these are all things, when you decide what you think you want to do, go find some people that do that. Most attorneys in our profession welcome young people that want to come shadow them, find out more about what they're doing. So I highly encourage that. We have time for 1 or 2 more questions.
How do you assure that both parties have a fair and unbiased hearing during these procedures?
Well, the process itself here lends itself. They get 20 minutes, get to reserve some time. They get to, so as far as their opportunity to be heard, they have the opportunity to file their briefs, and then an answer brief and a reply brief. So the rules kind of set that out. As far as what we apply, you've heard a lot today of us talking about prior cases and how those get applied, but we're also not the final word. On many cases, we can get appealed up as well.
Yeah, on the appellate side, it's very fixed. We have very fixed rules. And so, the same set of procedures apply to everyone. And in trial courts, it's actually, I think, more difficult to always make sure you're being fair to both parties, because the individual trial judges have a lot more discretion over how their docket works. So you always need, as a trial judge, make sure you divide up the hearing time equally, because it's not naturally divided up. Hearings are not always 20 minutes and 20 minutes. Sometimes it might be 2 hours. Sometimes it might be 3 hours. There might not just be, 3 presentations. It might go back and forth for a while. So, with us, it's kind of preset for everything to be, fair and impartial for the parties. If you're a trial judge, you have to make sure you're doing that on your own, because the procedures don't naturally make sure things like people get equal time, things like that. You have to make sure that happens.
There's nowhere in the Constitution that says British Accreditation Regency has a right to rule over us. Title 15, Section 2 says monopoly of a trade is a felony. We have seen criminals in black robes violate our Constitution time and time again. We've lost almost completely our Fourth Amendment rights. We have spy cameras everywhere. We have corporations collecting our data and selling it without any monetary reimbursement or permission from us. We're losing every single right we have. What should we, the people, do when judges are the criminals?
Well, I think the great thing about America and the 250 years that we've been here, there is rule of law. And as I just said, we're not the final say. Do judges always get it right? No. That's why we're here, because trial judges don't get it right. And we have a Supreme Court over us, and then they have a court over them. So the other great thing is we're all entitled to our own opinion, our own perspective on things, and we have a public forum here. There's many places around the world today that don't enjoy this opportunity to even get around and come up and approach a podium and say what you just said. So I appreciate that you can have that view.
That's not my question. My question is, when should the American people arrest judges when they break the law?
So, and my answer is, the idea of a judge breaking the law, we're under the same laws as everyone else. If I speed, I can get a speeding ticket. If I steal something, I face the law the same as everyone else.
That's not true.
If you're talking about our decisions in breaking the law, that's not a breaking of the law. It's us interpreting the law, or the facts the way that we do it. And if we do that wrong, And if it's improper, then the parties on both sides have an opportunity to appeal that up. And that's how the process works. So it's not, if you're saying a decision that somebody made is breaking the law, then there is a way under the rule of law that gets appealed up.
People don't have access to those things. The judges violate our law.
And we're going to try to limit it to one
every
question
single time.
per person, though, okay? Any other, we got time for one more question?
More? Yes, ma'am, right here. Sure, please, please. Big voice.
Hi, I would like to ask you a question. What is one advice you can give so that everyone can perform their best while still being
Could you repeat one more time, a little louder?
What is some advice you can give so that everyone can do their best while still maintaining health?
Sure. So I tend to think put first things first, so identify the priorities in your life and make sure you give adequate time to those. So with your health, work out, go for walks, play with your dogs, or enjoy time with your family. Putting first things first, that means also remembering your job and your vocation are very important, and you need to do what is necessary there, but don't let the other important things in your life fall to the wayside. Make time for friends, make time for pursuits that bring you passion and that you enjoy. Have a well-balanced, full life, such that it can help keep you from getting too drained or too tired. But also be okay with yourself if you get to those points where you're feeling a little spent. That's just part of the human condition, that sometimes we just can't handle things. And that's when it's good to have people around you that care about you, that you trust, that you have involved in your life, that help to carry that burden with you.
Just take that into account also when you choose your profession, right? In any job, you obviously want to take care of yourself to the extent you can, and everything Judge Pratt said. There are jobs that are just inherently higher stress. If you work in an ER, there's going to be some stress. And if you don't want that stress, don't work in an ER. If you're a trial attorney, there's going to be some long nights. There's going to be some long weeks where if you're in trial and it's 3 weeks long, for that 3-week period, you're going to be working all night, every night, and you're going to be up early in the next morning in court. If that sounds like something that wouldn't be appealing, don't be a trial attorney. You got to understand, what your personality is and where it fits, and pick something that fits your personality.
Even in appellate law, I'm sure we could ask, and I'm not going to, how many hours in the last week to 10 days, it goes back months before that they've spent on these cases. It's just a very time intensive, but they do have the benefit of knowing that we were going to arrive here at 10 o'clock this morning, and that somewhere by 11 o'clock, unless something had gone awry, that this would be over for them. You don't always get that in a trial, and you don't know what's going to happen, and all the twists and turns can really be difficult. And as Judge Mize said, if that's something that causes you great anxiety to just think about it, then that's probably not the area of the law for you. Well, thank you all very much for being attentive today and listening and being polite.
Thank you.